We'll now proceed with the workshop on alternative dispute resolution. And the first part of this second session concerns the duties of the professional actors that are involved in the mediation and ADR process. And here, I would like to give the floor first to Mrs. Katarzyna Seifert, who is an accredited mediator and a legal assistant at the Boards of Appeal of the EUIPO. Kasia will deliver a presentation on the duties of the mediator, and then Ms. Suzy Skardokia, also accredited mediator and legal assistant of the Boards of Appeal, will give a presentation on the duties of lawyers representing the parties and participating in the process. So please, the floor is yours.
Okay, thank you, Kirsten. It's really a pleasure to be here and to participate in this seminar, although we've been just chatting with Suzy that we've got these wonderful tools that allow us to meet online, but it would be great actually to be able to go to Tbilisi, although I saw that the weather was quite hot today. So I will talk about the mediator, about his duties, his or her duties in the process, about his role and how he conducts the process and how he deals with the parties. When preparing this, I actually looked for, apart from showing the basic information, I tried to look for some illustration of the qualities of the mediator, and I actually bumped into a website entitled, a blog article entitled 212 Qualities of Good Mediator. So starting from active, adaptable, caring, careful, brave, flexible. I could probably go on through the whole presentation about the desired qualities of the mediator, how charismatic and psychologically oriented he or she should be. But I will maybe just focus on the essential functions. So who is the mediator? It's a third-party professional. And when I say professional, I mean professional in the sense of a trained mediator. So someone who has done the proper training and has got the experience as the mediator, but it's also desirable that the mediator actually knows about the businesses, which is at the root of the conflict. So of course, in cases of trademark disputes, it is important that he or she knows the trademark law. If it's a construction dispute, I think it would be losing a little bit of credibility if he does not understand what's there. So it's a third-party professional, third-party neutral, impartial. So he cannot have any personal or professional links to any of the parties or its representatives. He's not there to resolve a dispute, so he's not a judge. There is no point for the parties to convince that who is right, who is wrong, who's stronger, who's got better case, because he's not really to judge. He should not advise the parties, so he's not there to give a legal advice or to help of any parties. His role is to facilitate dialogue, to assist the parties in finding a solution. So the mediator is helping the parties really to talk and to find a solution themselves. As the mediation is a structured process, he is also sort of making sure that the procedure is followed and that time is respected. As we've seen before, then there are certain phases to the mediation. It starts with the very day of the mediation starts with the opening statements of the parties. Then there are private meetings. Then the mediator has to make sure that he treats both parties equally, so the same time is given to one party. If for some reason it has to be extended, then the other party should also be able to have more time of the mediator. And apart from being truly disconnected from both parties, truly impartial in his acts, he should also make sure that it simply looks like he's treating both parties equally. And as I said, his role is there to help the parties talk and to find to get a global vision of the situation and to find a solution. It is the parties who find a solution, who go for the settlement. It's not something that mediator is proposing. Maybe before this, I will just jump to the 6th slide, just to continue a little bit on this formal requirements of a mediator. So as I said, he cannot have any professional or personal links with either of the parties. And he's what is at the very heart, and I think it was already said in this conference, confidentiality is at the very heart of mediation. So it is for the mediator to assure confidentiality of the whole process, and it is the confidentiality at, so to say, 2 levels. So as we said before, any information, documents, evidence revealed in the course of mediation proceedings cannot go outside the room, but also when the mediator meets one of the parties only, he is supposed to keep all the information gathered within that room and not to reveal this information to the other party. It's extremely important that the parties trust the mediator, but this information will stay between them. So every meeting at the end, what the mediator typically does is summing up what has been said in the private meeting with the party, and then assuring the party that it will not be revealed to the other party unless there is an express authorization. So in practice, it can vary, because obviously at some point, some information has to be revealed to the other party to be able to progress. So this all will be consulted with the parties and representatives. So typically, we would sum up what has been said, and as a mediator, I would say, I will not reveal this to the other party, but perhaps we could tell them this and this, and then provided that the party agrees, we can release some less confidential or less sensitive information stage by stage. The mediator has to treat the parties with respect. He shows empathy, but of course, as I said, he is in the middle. He cannot favor of the parties, even if it may happen that at some stage the mediator can think that one party is good guys and the other party is bad guys. He has to be impartial until the very end. He respects the party's solution, even if sometimes they may seem unfair or not right to him. He would only signal when the proposed settlement may involve the completely unrealistic or illegal issues. And the mediator is all ears. This is especially important at the very initial stage of the proceedings. So at the after the opening statements, at the exploration phase, the mediator has to listen actively. So he has to ask questions to find out what is behind the parties' positions, because the parties would come with their statements regarding the case, their demands, but what mediators really role is to find out what are the real interests of the parties. All this with the confidentiality clause, no judging, no advising, no reproaching. As we often say, a conflict is actually and can be illustrated by an iceberg. So we have what we see, which is on the paper, which is this fierce statements. We demand this. We want you to stop using the mark. But what is below and what is often not seen by the outside world is the parties' interests, experiences, needs. So this is all that has to come out, or should ideally come out, in the process of the mediation. What happens very often in the case of trademark disputes that we have before our office is that, first of all, conflict appears more grave on the paper than it is in the reality. And then there is this reaction, defense, and then the next reaction. So let's say the applicant files a trademark, meets an opposition, so he would attack another trademark. And in many cases, there can be parties which actually maybe don't meet, in fact, on the market. They can be an applicant from Estonia and an opponent from Portugal, and maybe they may have similar trademarks, but not real conflict on the market. So there is really a big room for finding what's really important for the parties. And what is the alternative to trying to invalidate each other's trademarks? Maybe there could be a room for coexistence. Maybe there could be a room even for cooperation. Summing up, impartiality, confidentiality, it's that we never have enough of this. We can come up, and it will probably come back again during this seminar. But these are the really core features of the mediation process. Active listening skills, respect, and patience. This is a very interesting thing, because patience, as I tried to illustrate here in the image before, it does not mean just waiting, because obviously, especially at the first stage of the exploration phase, the mediator listens. When it comes to bargaining phase, he's already a little bit more active and trying also to persuade the parties how an offer can be save the parties from so-called insult offers, trying to make the party look from the other perspective. At the last mediation I was assisting as a shadow mediator took virtually 2 full days. These were 2 days of my holidays on the top of it. So it really seemed extremely long. But the mediator needs to have this understanding when the situation is developing. Of course, he would stop the parties if he sees that no progress is being made, and then there is really no hope for agreement. But as long as parties are moving towards the agreement, even if it's very slowly, he just needs to assist as long as possible. He has to be flexible and understand the psychology. It is useful to have some sense of humor, especially when these days tend to be very long, and people are getting tired, and they are inevitably these ups and downs. But of course, we have to remember that we are not in a festive situation. It is a mediation, it's a business context. So also with the cultural difference, it can get very tricky. And at the end of the day, he or she needs to have this authoritarian approach, because obviously the mediation is for the parties. The parties are masters of the process, but the mediator controls the situation, and when it comes to the deadlock or to the situation where one party is abusing the situation or going a little bit too far, or simply not listening. There is this moment when the mediator has to intervene. And I think I will stop here. I was about to talk about the different mediation styles, but I'd rather leave some time for questions and for Susie's presentation here. Thank you.
Thank you, Kastya. We now move to Susie, and we'll take the questions at the end of this part. Okay? Thank you. I will give the floor to Susie Skadokia.
Well, thank you very much for I'm happy to be here. Like Kasia, I would rather be in Georgia, but hopefully next time. So I will tell you first of all how my presentation will be structured. I will first talk about some common misconceptions regarding the role of lawyers in mediation. Then I will talk about how the decision is made by the lawyer to advise his client to mediate. I will talk about how the lawyer prepares for the mediation. And then I will move on to the lawyer's duties during the actual mediation. And finally, I will talk about what the lawyers do at the conclusion of the mediation. So first of all, I would like to start by saying that there's a traditional misconception about what lawyers think about mediation. A lot of people think that lawyers would automatically be against mediation because they are traditionally adversarial. They are primarily law-focused. They are used to being in court and they want to fight and they want to prove that their client is right and that they try their very best to defeat the other party. Now, as you probably understood by now, mediation is not about winning and losing. There has to be a shift in the way lawyers approach this, but nevertheless, the lawyer's role is equally important in a mediation as it is in court. Lawyers need different skills in mediation. They need to shift from focusing on being right to focusing on being useful for the client. And in the next slides, I will try to show you how this is done and how important it is. So first of all, the lawyer plays an essential role in discussing with the client whether a case is appropriate or not for mediation. And in order to do this, the lawyer has to have a very complete and thorough understanding of mediation, both in terms of its process and in terms of the principles behind it. And he is then the one who educates the client in this respect. And then the specific case is assessed. All the relevant factors need to be taken into account. The nature of the case, the need to keep the conflict confidential, because of course mediation gives the opportunity of keeping a dispute with another company completely non-public. It is not made public. The client's wish for a more timely solution is of course very important as well. So the lawyer must assess all this together with the client. Another very important aspect that I would like to mention is that mediation gives the opportunity to the party to maintain business relations with the other party. And in all of this, of course, the best interests of the client are of the essence. And if the client is happy at the end of the mediation procedure, then this, of course, also has advantages for the lawyer, because the client will undoubtedly give credit to the lawyer for the success. So moving on, how does the lawyer prepare for the mediation together with the client? Well, first of all, the lawyer can assist the client in choosing the mediator. We have already seen earlier how the mediator is chosen. So I won't repeat the factors to take into account. Then the case needs to be discussed together with the client. What are the main issues? What are the case's strengths and weaknesses? And most importantly, what are the client's expectations? What might the client be willing to give up? And what is really, really of the essence and significant for the client? So on the basis of all of this, the lawyer, together with the client, prepares the initial case summary that is submitted to the mediator. And then the opening statement is prepared for the day of mediation. Now, in theory, the opening statement can either be delivered by the lawyer or by the client. However, from my experience, it's always been the lawyer. And in some cases, the client then adds something. And so, as you can see, the role of the lawyer is very, very important. And I would like to say that this is also the reason why more and more lawyers are on board. They're going from being mediation adversaries to being mediation advocates. Now, one last thing I would like to mention before I move on to the next slide is confidential information. Now, we've already seen how important confidentiality is in mediation. And it is the lawyer's task to discuss with the client ahead of the day which information can be shared with the other party and which information should perhaps, at least in the beginning, only be shared with the mediator. Now, during the mediation, the lawyer provides expert advice, and in particular, legal advice. However, in all other respects, and also with respect to commercial interest, the lawyer can clearly help the client because he knows the dispute best. In terms of legal advice, the lawyer can provide assistance with respect to known legal issues, but particularly also if any new legal issues arise. And it is also the lawyer's task to always discuss with the client in the course of the mediation what the common ground might be. In other words, from the other party's statements, can any shared interests already be identified? And the other thing that is very, very important is that in the beginning of mediations, the parties tend to be very nervous because obviously they're in a dispute and they tend to also sometimes show some aggressive behavior towards the other party. And it is the lawyer's responsibility to also help in reassuring the client and keeping the client calm. So for all of these reasons, at least in an ideal world, the lawyer should be an assistance and a help to the mediator. Now, you can probably imagine that this does not always happen, but this is the way we as mediators, we would like the mediation to be. It is true that the mediation is, in the mediation, it is the client who plays the central role, the lead role. However, the lawyer is there to assist the client, to calm the client down, as we've already seen, to give the client advice, both legally or otherwise. And in all of these respects, this helps the mediator's work. Also, the lawyer has to maintain a positive attitude to make sure that the client does not lose faith in case everything moves slowly in the beginning. So for all of these reasons, I would say that at least in an ideal world, the lawyer should be seen as the mediator's ally and not as an obstacle. So moving on, at some point, hopefully the negotiation phase is reached. And it is important to stress that the lawyer's role in negotiations is not necessarily to carry out the negotiation. Why is this? Well, from my experience, the clients are generally themselves very experienced business people. So as a result, they are very good at negotiating. But what the lawyer does is, of course, he can discuss the offers with the client, and He can compare views with the client, but to think outside the box, to explore different solutions. So he's there to exchange the points of view on how the mediation is going and where a possible solution might lie. Now, what is also very important for the lawyer is that he or she carries out reality checks. Now, I know that this is traditionally also done by the mediator, but the lawyer also does it. He reminds the client what would happen if the mediation had not taken place or if no agreement is reached. What is the best thing that could happen? The BATNA. What is the worst case scenario? The WATNA. And it is very important that the lawyer always makes sure to keep that the client's expectations are kept in check. So the last phase of the mediation is, of course, the termination. If it is successful, that's great. I have, by the way, added a little slide that is COVID friendly in terms of handshaking. So it is the lawyer's duty to actually draft the settlement agreement. This is one of the most important duties of the lawyer. The settlement agreement is drafted in accordance with the terms of the agreement, and of course in full compliance of the law. And finally, making sure that the agreement is actually enforceable. However, even if no agreement is found, or only a partial agreement, it is still to be considered a success. Why is this? Well, the lawyer will have had a chance to get to know his client better. The parties will inevitably have come closer, which means that an agreement might be reached at a later stage, which, as my colleagues have mentioned, often happens at EUIPO mediations, or an agreement might be reached on only a part of the dispute. So whatever happens, I think mediation is a great idea. And overall, I say, trust the process. Thank you very much.
Thank you, Susie. Thank you also, Kasia, for your presentations. I will now open the floor for questions on the duties of mediators and of lawyers. Okay, we have a first question. What are the mechanisms for ensuring mediators are in line with the criteria established for them? So I would like to give the floor to Kasia to reply to this question.
It's the mediator's integrity behind they are obliged to follow the rules by the rule of conduct. And obviously it's also in the mediator's best interest to maintain the trust and of the parties and the representatives. I think that simply a mediator cannot afford not to follow and especially not to break the confidentiality rules. I don't know if anyone would like to add anything on this.
Thank you, Kasia. I think that's Sven Sturman. Sven, the floor is yours.
Thank you, Kirsten. Yeah, I fully agree with Kasia. And maybe just to add, for the EUIPO, first, all our mediators are internationally accredited mediators. We have the CEDR, or the CEDR or the CIDB accreditation, which are very high level international accreditations. So that's very important. And what we also do, we have, of course, led by Kirsten, the ADR service, which takes care and coordinates all the different issues on the mediators, and to guarantee that there is a coherent and consistent application of these mechanisms and rules. And that's the reason why we organize twice a year a mock mediation with the internal mediators, where all the mediators have to act as mediators, and they will be observed by very experienced colleagues and even external experts. And then we discuss these cases, we draw conclusions, and then we decide if we maybe have to change our approaches. So, but these mock mediations are very, very important to guarantee that everybody is applying the mechanisms in the right way. And then, of course, the ADR service also organizes frequently meetings where we discuss specific topics on how to conduct mediations. Thank you.
Thank you so much, Sven, for this clarification. I cannot see. Yes, Gordon wishes to add a comment. Gordon, the floor is yours.
One very quick comment that obviously we send out questionnaires when the mediation is finished, so we get feedback from the parties, and if anything needs improving, we take careful note of comments, both good and bad, that the parties have, and try and always strive for self-improvement. Thanks.
Thank you, Gordon. That is really also important. And in the case of EUIPO mediators, we also need to ensure you that all the mediators that we are offering on the website, they are statutory staff of the EUIPO. That means that they are staff that are bound by our staff regulations of the EU, and here we have very clear instructions that we are bound but to be independent and neutral and not abiding to any government instructions in that side. So we have another question: are the lawyers who help the parties in mediation basically in-house lawyers who know the business, or mostly law firm lawyers?
Should I answer? Yes.
Yes, please,
Okay.
Susie. I would turn to you.
Yes. I would say, from my experience, they've mainly been law firm lawyers. I don't know if this is a trend, or, but I would also say that yes, there's nothing impeding in-house lawyers. Sorry, I have problems pronouncing that word. In-house lawyers from participating in a mediation. I don't know if any of my colleagues have anything to say about this.
Kirsten, if you allow me.
Yes, of course, Sven.
Yeah.
The floor is yours.
Thank you. I fully agree with Yuzi, and maybe we could highlight that actually the mediation process has an advantage, because here the parties can, let's say, participate all their lawyers, being in-house, external lawyers, or whatever. So I think this is a big advantage, because in many countries, for example, in the case of the EUIPO, if you are a third country applicant, so not from the EU, you need to have a representative who is based in the EU. Yeah, and usually this is then a contract lawyer of the company, but it's not the lawyer, not either the in-house lawyer or the external local lawyer. It's another one. So in the mediation process, a bit advantages. The parties are free to come with whatever lawyer they want, be it an in-house, their closest lawyer, and then another lawyer based in this specific countries where the conflict has arisen. So that I think is a big advantage. And of course also other persons can participate in the mediation process. So we have much more flexibility as in court proceedings, for example.
Absolutely, Sven. This is an important aspect, and it highlights the flexibility of the process, and that the parties' design are part of the design of the process themselves. Gordon, you wish to add a comment, please? The floor is yours.
Yeah, thanks. I'd just say that when one of the parties is a larger corporation, it tends to be the case that we get in-house lawyers coming. This is particularly true with US corporations. They nearly always send their in-house lawyers. And this has good and bad points to it. Good because obviously we welcome engagement directly with the clients, and we need this. Bad because, or challenging, let's say, because they are not directly the business people, and therefore they're sort of delegated responsibility by top management, the board of directors. And this, of course, can present a challenge when it comes to decision making, because although they're given instructions and they will tell you, yes, we're fully authorized, what they don't say is we're authorized up to certain amounts. We have a number of constraints on our authorizations. Of course, we know this, but until it would be quite rare that we're able to build up in one day the sufficient level of trust that they tell us exactly what their negotiating mandate is. They tend to keep those cards quite close to their chest. And therefore, what you have to do is make sure that firstly you understand the decision-making process, because if it's a large corporation, as I say, it's not the in-house lawyers that are going to make the final decision. They have to run offers past their management sometimes if they go to the limit or beyond of what they're authorized to do. So you have to be very careful that you understand that decision-making process. And secondly, that you're able to get them to contact their senior management immediately and get the decisions immediately, not within 3 hours, because otherwise you've got everybody in the mediation at a standstill, getting super frustrated because they actually say, we haven't got the right people at the table. And the danger is, of course, that you as the mediator get blamed for not having the right people at the table. So my experience is in-house lawyers, good, but make sure you've got all the agility of decision-making taken care of.
Thank you, Gordon. That is a very important aspect. And we have Sven, who wishes to add a comment. So Sven, the floor is yours.
Yeah, thank you. Yeah, Gordon has raised a very important issue on this, and I just would like to remember that even if the parties come and show you, let's say, a document which gives them the power to decide whatever way they want. And I had one of these mediations, and actually it was an international with the Hague apostille, so they could really in the power. They got a power from the owner of the company. They could have even sold the company. But even if you have this, you cannot rely on this, because it might be, and it will be definitely like this, that the owner or the top CEO, as Gordon has said before, will have given instructions, limits to that person. Even on the legally speaking, he could or she could have sold the company or done whatever he or she wanted, but there will be definitely internal limits. So you need to find out these limits, and you need to address that ideally even before you start the mediation process, so that you avoid the situation Gordon has mentioned, which can be very counterproductive for the process of the mediation. Thank you.
Thank you, Sven.
Excuse me,
Yes.
can I have a question?
Of course.
My name is Teona, and I work at Sakpatenti at the legal department. My first question would be, in the last presentation, we heard that the final agreement drafted by the lawyer needs to be in accordance with law. Who is responsible to check whether the agreement is in accordance with law, and what is the mediator's role in this process to review the final agreement? And for my second question, it would be, it was mentioned that individuals can participate in mediation proceedings without lawyer. And in this case, who is responsible for drafting the final agreement on behalf of that party? And if mediator gets involved also in this process, in this case. And for my third question, I understand that the mediation as a whole is quite a long process, but actual mediation takes only 1 day. So is there any reasons behind it? Why just only 1 day? And if it can be prolonged in some cases? Thank you very much, and thank you very much for your very interesting presentations.
Thank you, Teona. I will turn first to Susie, and then maybe Sven and Gordon wish to add any comment. So, Susie, please.
Well, I don't want to take over from Kasia because I think she's the one best qualified for responding to the questions about the mediator. I just wanted to comment on the question regarding the participation in mediation without a lawyer. Now, that is, of course, an option, but what needs to be borne in mind is that there shouldn't be a feeling of imbalance for the party who is not represented by the lawyer if the other party has a lawyer present. So this is something that needs to be borne in mind. It is, of course, I would say, still the mediator's responsibility to deal with this issue. But overall, perhaps if only for this reason, my recommendation would be to try to have a lawyer present if possible.
Thank you, Susie. Kasia, do you wish to add on Susie's
Yeah, maybe
comment?
I will answer the question regarding to drafting and assuring that the settlement agreement is in line, is not illegal, so to say, because that's what my understanding was the question. So it is the lawyer's responsibility to draft the settlement agreement, and it's also their responsibility to make sure that it's in compliance with the law. Of course, the mediator is there, and he may signal if there is some obvious problem. But we have to bear in mind that we are here dealing with several legal systems, so we cannot expect the mediator to know what may be on the edge of being legal or illegal in Portugal, Lithuania, Belgium, and Italy. So this is the party's responsibility, the lawyer's responsibility. And if there is something which is clearly a problem, the mediator can signal, can draw the representative attention to that, but it's not his responsibility. Now, I don't know, because then we have the question about why it's only one day, but I don't know if anyone would like to add something on the legality.
I would like to add something, because it is actually something that perhaps I should have mentioned in my presentation. That it is true that the lawyers draft the settlement agreement in accordance with the law. And it is indeed also their responsibility, because the mediator is not responsible for the actual solution that is reached. So I think that is very important, that this is one of the basic principles of the mediator's role.
Thank you, Susie. Gordon, you wish to add?
Yeah, just a few thoughts. Firstly, I'd say that I usually find myself being the typist in these situations. Obviously, it's sort of one of the penalties of being an English native speaker is that people are very happy for me to review their document from a linguistic point of view, and which I'm happy to do, but obviously the legal content is their responsibility. The second point, more serious, is perhaps that while it's true what Kasia says, that we can't know all the legal systems, and bearing in mind that we have over a third of all applicants at the EUIPO, nearly 40% actually, are from third countries. We would have to know virtually every legal system in the world, which is not really possible. But what we can do is, and which Kasia hinted at, or Susie actually, is point out a few things in case the parties have forgotten them. For instance, jurisdiction. Is there a jurisdiction clause in the settlement agreement? How are you going to deal with whose law applies? So an applicable law clause, and what courts will be competent, or are you looking at arbitration, or what mechanism have you got? Also, sometimes people may forget in the sort of joy of reaching a settlement, they may have forgotten about what they actually need to do at the EUIPO and other IP offices, such as, lift the suspension, issue apply for a withdrawal of the action, and the other administrative steps that need to be taken. So of course we should remind them, look, there are a few things you need to do at the EUIPO and maybe elsewhere. Have you covered them, and what are you going to do there? And just some common sense. I mean, if we saw that there was potentially an antitrust problem, competition law. I mean, I don't think any of us are real competition law specialists, but we may need to say at a certain time, even that would probably come at an earlier stage, but just to head off a problem, make sure that the parties understand that is the solution proposed legal. If we saw that there was obviously something quite obvious that could give rise to illegality of one sort or another, it would be our duty to point it out. I have to say that's actually never happened to me, but theoretically that's something that can be done. Thanks.
Thank you, Gordon. I now turn to, we have another question here, but I would like to ask if these questions were properly addressed, or if we have left out.
I think we left out the question, why is it only one day?
Absolutely, yes. So Kasia, for you to.
Well, I think that think of one day, it's not, maybe it comes from the time when it was done physically. So of course, it's not just one day and everything is solved, because there is a lot of preparation before in order to get the parties together and to have business people blocking one working day, but living with the solution. If I understand correctly, it's also the experience saying that if we cannot move forward, if we cannot make real progress in one day, then probably it's either not going well, or maybe it's actually better to leave the things and then come back later, because it doesn't, as we already said, it very often happens that no agreement is reached during the day, but then parties have actually come together, understood their interests better, and maybe in 2 weeks' time they will, already without a mediator, or maybe with the help of the mediator, they will come back with a proposed solution. So yeah, one day, yes, but sometimes it's not just one day. I don't know if anyone would maybe like to clarify further this.
Thank you, Kasia. I think that this also gives an idea of the flexibility of the process. We now have another question in the chat. It seems that involvement of lawyers is really important even for big businesses, and in this case, is the mediation process still cost effective unless multiple disputes in different jurisdictions can be solved by one mediation procedure? I would like to give the floor to Susie.
Yes, I'm actually really glad that this matter was raised, because I was wondering whether to put it into my presentation. Now, this is one of the reasons why lawyers have to be very familiar with mediation and have to know the ins and outs. Because it is true that even in mediation, given that lawyers are paid on an hourly basis, there can be quite lengthy meetings with the client beforehand. And this, of course, adds up to the bill. So it is very, very important that the lawyer keeps an eye on effective use of time. And if the lawyer is capable of doing this, then I would say that mediation can be a quicker solution and a more cost-effective solution for the client, even in more simple disputes. So not only when there are several jurisdictions or multiple disputes. Thank you.
Thank you, Susie.
If I can quickly add to this, because I think apart from this cost-effective solution, the very important advantage of mediation is the legal certainty. because obviously it may be costly to come to a solution, but somehow the settlement guarantees that the solution will not be appealed, when there will be no obstacle to its, well, not guarantees, but gives a better protection when it comes to enforcement and possible further appeals. And it is basically what the both parties wanted. So even when the costs at the end of the day may be comparable, I think it may be still more attractive for the parties.
Thank you, Kasia. Always future looking and with the good relationship in mind. We have one hand raised. So Eleni Sekhnashvili, sorry for pronouncing your name incorrectly.
And my name is Eleni Sekhnashvili. Thank you very much for your excellent presentations and clarifications. I would like to add one question about the mediators. As I see from the CVs of the excellent mediators at the EUIPO, as I understand, they're all staff of the EUIPO, and I also saw that the training of mediators are important, and I see quite a mandatory part of any mediator to be able to work as a case handler at the EUIPO. So I would like to ask whether these trainings are mandatory and what are the criteria of selecting the staff members which are later able to act as mediators at the EUIPO. And as I found out from your presentations and from the information provided, the mediators or arbitrators, which are not part or the staff members of the EUIPO, are not the official mediators, but I guess they can act as co-mediators in the proceedings. So would you provide some more clarifications about that? Thank you very much.
Thank you, Eleni. I would like to turn to Sven to reply to this question, please.
Yes, thank you. Yes. I mean, only those who are listed in the on the external website, and those who have done the trainings can act as mediators and also as co-mediators. No, as Kirsten Bauch has said, that so far the mediators are all internal staff. They're all internal staff, and it's absolutely required. They need to do this external training. I mentioned also already before the official accreditation, but they also need to undergo the training subsequently to that accreditation process, the training which we offer internally to the new mediators. So in order to make sure that the mediations are done in the highest quality possible for the users.
Thank you, Sven. And if I may add also that newly accredited mediators, they may also be shadow mediating for cases so as to acquire more knowledge and experience before they take up a case.
And Kirsten, if you allow me, because there was a question on how we select the mediators. I mean, the criteria, I mean, one very important criteria obviously is for us the language, because we would like, I mean, the EUIPO has 5 working languages, but of course we work also in all the other 17 languages of the official language of the EU. So when we appoint or select new mediators, we always have a look also of the languages in order to offer to the parties the broadest variety of languages. And that is, of course, one criteria. And another criteria, of course, is the experience in IP in general, not only trademarks and designs, what is our core business, but also the general experience in IP matters. So these I would say are 2 very important criteria to select any potential new mediators for our team.
Thank you, Sven. And of course, the mediators, they have to want to become a mediator, which is also very important in order to be able to drive the process in a very positive way. Eleni, I don't know if we have answered satisfactorily to your questions.
Yes, thank you very much. So I guess the mediators who are trained as mediators or perhaps are members of the mediation association would not be able to be mediators in such proceedings. What do you think about the Georgian model? Can we invite the mediators which are outside the staff of the National Intellectual Property Office, and whether this would be in principle in correspondence with the principles that you have stated? Thank you.
Thank you, Eleni. Our basic regulation foresees the possibility of working with external mediators. The only thing is that up till now, we have only worked with internal mediators, but there is a plan to explore that possibility in the future. So of course, any experience that you may have, we could have exchanges on your experience and the knowledge that you acquire in that sense. So we are still open to that possibility. However, for the moment, we have not reached that stage of the process yet. We are working only with internal mediators.
Thank you very much.
Kirsten, could I add one point here, please?
Of course, Sven.
Thank you. I mean, this question on internal and external mediators is very important, and one of the main reasons why we have so far focused more on internal ones is that there's one aspect which you need to consider when you discuss this also at your offices, the issue of quality and control. I mean, of course, if you have a list of external mediators, and as everything is confidential, it's very important that we as an institution also guarantee that the mediations are conducted in the way we wanted to do, as we have explained already now in the different presentations. And this, of course, can be done much more easier if you have internal mediators, because if you have external mediators, as is the case in EUIPO, of course, I would say there's a certain limit to guarantee, or let's say to supervise that the mediations are done in the way we want to do it in accordance with our philosophy. But nevertheless, as Kirsten has said, we of course also need to open our minds and need to have a look at the possibility for external mediators and need to set up a system. But I think then we really need to have a mechanism and a quality check system so that we can really guarantee that the mediations are also done by the external mediators in the same quality as done by the internal mediators. Thank you.
Thank you, Sven. I think that Gordon wants to add something, so the floor is yours.
Yeah, just a few points. The first, I think, is that when you use private mediators, there's obviously a cost element there, which is an important consideration. Mediation at EUIPO is very good. There's obviously a different scale of costs to the mediations that we do at the EUIPO. The second point is that our mediation process is voluntary. So if the parties want to take a mediator anywhere in the world, if both of them agree on some other mediator anywhere in the world, including EUIPO or wherever, we're very happy for them to use those services if that's what they want. So there's no obligation to use us. And the third point is, because China has just risen so quickly in the last 5 years and has become now the #1 filer at the EUIPO, we actually have a cooperation mechanism with the Shanghai Commercial Mediation Center for co-mediations for Europeans or Chinese involved in either country where disputes arise and where one of the parties may feel happier having a Chinese mediator co-mediating with us. So I mean, that's a sort of a beginning of trying to accommodate for the new realities that we all live in, I think, everywhere in the world, basically. Thank you.
Thank you, Gordon. I can see no further questions under this part. There will be still chance to ask questions after the next presentations. So I will suggest that we go directly to the second part of this session that will focus on the mediation working methodology as we apply it in the EUIPO. And this item will be presented by Mrs. Sophie Petrequin, who is an accredited mediator and a legal assistant of the Boards of Appeal. And then we'll close the session with a presentation of Mr. Gordon Humphreys, who will refer to some of the many examples of successful mediations before the EUIPO that has been taken from his long experience as mediators. Sophie and then Gordon, the floor is yours. Thank you.
Thank you very much. So I've been asked to talk about mediation working methodology and to cover the following points. Many points have been already answered, especially by the questions, but so I will try to not to repeat and to maybe to give practical advice. So we will talk first about identifying issues and common ground, then formulating offers and bargaining, and the last point, concluding the mediation process. I have put a slide on the 5 phases of mediation. We have already talked about the importance of preparation. We talk about the opening, and then we will talk here about exploration, bargaining, and concluding. You see that you can always come back to exploration if it's necessary during the mediation process. So we would identify issues and common ground during the first phase, which is the exploration phase. As already explained, the initial joint session will start with an opening statement. And here I would like to point out that it's important that you ask, if possible, the client, the representative of the company, to make the opening statement. Otherwise, if the lawyer is doing it, he will tend to focus on legal issue and to do a pleading, like a pleading before the court, and it's not what we need. During this opening statement, the party will explain their position and what they expect from the mediation. Many times it will be also the first time that the business people meet and talk to each other. And so it's a very important moment. As I also explained, we will try to draft an agenda for the day. It means the issues that we will dealing with. And here already some common ground might be identified. It's always good to start with something positive. And we will also, of course, mention the areas remaining in dispute. After this, we will start with individual private sessions with each party. Here, it would be important to spend an equal amount of time with each party so that no party feels that the mediator favors the other party. In practice, you would say, okay, I will start with party A, and let's do a private session of about 20-30 minutes. Then I will come to party B. If you realize that you need more time, it's important to inform party B that maybe you need 5-10 minutes more so that they don't feel impatient. In case of co-mediation, it's also important that you make aware the party that one mediator is not the mediator of one of the party and the other mediator is the mediator of the other party, because both mediators are working together. It's a co-mediation. Parties may have this feeling if one mediator is of the nationality of one party and the other mediator has the nationality of the other party. But it's the role of the mediator to clearly explain this, because anyway, the mediator is not the party representative or lawyer. We also insisted several times that the mediator has to build trust, and this is especially important during the exploration phase. Otherwise, the party wouldn't talk if they don't trust the mediator. If the party express emotions, which may happen even with dealing with trademark issues, it's important that the mediator acknowledge these emotions and explore those emotions. It's really recommendable to deal with this emotion during this first phase of the mediation, the exploration, rather than waiting for the bargaining phase. We have been asked several times whether when doing online mediation, you can perceive the emotions. Indeed, it's different. It's very different than when you see people in real. But with the experience, you see that you can see the emotions. You will have to ask the party participating to the mediation to keep their camera on, so they should not hide behind their screens. And you can see their reaction, how they behave. You can see if they listen to you. You can see if they constantly remain silent. Maybe it means they have something to say. During this private session, so we will dig into all the facts that underline all the issues that have been identified. For this, it's important to ask open questions. For example, we would ask, what suggestion do you have? Why is that especially important to you? Or what would happen if? Here, as we said before, it's before the EUIPO, you can the party can decide to include in the mediation the litigation pending before the EUIPO and also all other litigation. So it's highly important to dig into all the different litigations and why this happened. And why are the commercial interests behind all these litigations? Of course, during this phase, when you ask a question, the party will start with positional point of view, but the role of the mediator is to get behind those positions and try to understand the needs and interest versus those positions. Maybe because the lawyers are present, you will have to start off with some legal issue, but then gradually and very quick, you have to gain behind those legal issues. If the lawyer wants still to focus on legal merits, this is the role of the mediator to refocus on commercial interest and to explain that legal issue will be discussed if appropriate. It could be appropriate to go back to legal issues in the bargaining phase when there is a deadlock and you need to do a reality testing. Then you go back to the legal problem. For this, the lawyer has to understand that it is the mediator who masters the process. It may be difficult for lawyers because lawyers are used to drive the process, and the client is listening to the lawyer, and in court, the judge drive the hearing, but the mediator, the lawyers says what he wants. Here, you are ready to make sure that the lawyer has understood that you are driving the process. To summarize, and we also said it during this exploration, the role of the mediator is to move the party from the past to the future. Then, after this exploration phase, we will move on to the parties for formulating offers. And after the first offer, we would go into bargaining and negotiations. This is done first in individual private session, and then when the negotiation is well advanced, the mediator can decide to do intermittent joint sessions. I will not repeat again the importance of confidentiality, because I think you understood it, but this is really essential. What happens if we get an offer that is totally unrealistic, and what we call in mediation the insult offer? The mediator must realize that this offer is not realistic and should not convey this offer to the other party, because it will obviously link to a deadlock. So what should he do? First, the party who makes the offer needs to be able to explain why this offer is being made, how the amount of money is calculated, if money is involved, and on which basis. Second, we can try to get the party consider how the other party would react to the offer. We would ask him we would ask to the party making the offer to answer from the point of view of the other party. And what do you think? Does it sound fair and reasonable? If you use this technique, most of the time the party will reconsider his or her offer. In case of deadlock, we use evaluative mediation techniques. We already talked about it, so I will not repeat. And reality testing, we want to bring the party to what we call the ZOPLA, the zone of possible agreement. For example, we can ask questions for reality testing, like what would happen if you cannot settle and you go to court? What would be the cost? Here you have to remind the party that the cost of a litigation are not only the lawyer's cost before the court, but are also the internal cost of the company, the cost of the in-house lawyer, the cost of the litigation service in-house, and this may be really high. The mediator also in certain cases will have to reformulate some terms or the offer which is made, or present claims and proposal in a different way. For example, the English word damages may be understood in a very negative way, because damages is used in court. So maybe you would prefer to call this amount of money which has to be paid a compensation, or just an amount of money. Also, another example is the word to apologize. Depending on the different culture, this may lead to a deadlock, and this may be really negative in the process. So the mediator has to try to reformulate. At the EUIPO, we use facilitative mediation techniques. So as we already explained, the mediator is a facilitator. The mediator will not propose solution, but will try to help the party finding solution. Because at the end of the day, the best agreement comes from the parties who will have to apply this agreement, and not from the mediator. So by guiding the party, the mediator will try to make the pie bigger, to create value. And if the pie is bigger, there is more to share. a possible agreement in trademark litigation is not only the simple coexistent agreement that a party often signs. It can go beyond that. There can be commercial agreement, there can be a license, and you have as a mediator to dig into these possibilities. Then comes the conclusion of the mediation process. We already talked in detail about who drafts the settlement agreement. This is the lawyers. Sometimes the mediator may be involved, but it will be always with the assistance of the lawyers. In the mediation agreement that the party signs at the very beginning of the mediation, it is clearly mentioned that the mediator is not liable for legality and enforceability of the settlement agreement. We already indicated that it's important that the applicable law be mentioned in the settlement agreement, and this the mediator has to make aware the party that they shouldn't wait the last moment, because in practice, it's one of the last clause of the settlement agreement, but the parties should think about it before. And we also explained that the settlement agreement should include a clause identifying the competent jurisdictions, and it also may be foresee that mediation will be used in case of breach of the settlement agreement, or arbitration, or med-arb, which is mediation followed by arbitration. Then the mediator should clarify with the party what follow-up action need to be taken. If during the mediation only heads of agreement have been agreed on, then the lawyers have to draft the full settlement agreement and the parties have to sign it. You should put a deadline for this, usually 1 month. And it should be clarified who sends the mediation agreement to who. All these material actions need to be clarified. If settlement is not reached, we already said that anyway, it is important to take note of the progress achieved and also note the outstanding matter, and then the parties have to decide what the next steps are. In many cases, before the office, the party continue negotiating after the mediation if an agreement couldn't be signed. In such a case, the mediator informs the ADR service that the mediation is over, and it's the responsibility of the party to inform the Board of Appeal that they want to continue negotiating, and they ask for a further suspension of the proceedings. To conclude, the formal step at the EUIPO after mediation are first that we send a satisfaction questionnaire to the parties and the lawyer, as already mentioned. The mediator has to destroy all the documentation, and the parties must make a formal request of termination of the proceedings. In practice, at the office, for example, the appellant will withdraw the appeal, or the opponent will withdraw the opposition. If the parties reach an agreement on cost, they have to inform the board that an agreement of cost has been reached. Otherwise, the Board of Appeal will take a decision on cost. And once the parties have informed the Board of Appeal, the board will notify a decision closing the proceedings. Thank you.
Thank you, Sophie, for this enlightening walking through the the process and indicating our working methodology. Now I would like to turn to Gordon Humphreys, chairperson of the First and Third Board of Appeal. Gordon will give us a few very interesting, successful examples of mediation. So Gordon, this is your turn. The floor is yours. Thank you.
Okay, let's move into some cases that, well, I've actually taken them somewhat immodestly from my own experience, so please forgive me for that, but there are obviously some cases that I know quite well. Just an initial point that I'd make is that, I mean, often people said, well, trademark law, it's not emotional, so nobody's going to get emotional in these mediations. How wrong that statement is. People get very emotional with trademark matters in mediations, and it's part of the fascination of this subject is that mediations are about people, and people are very fascinating, and you end up being a bit of an amateur psychologist as a result. Okay, let's go straight into this. The first case that I'd like to talk to you about is actually one of the most recent mediations that I've been involved in, and that has come to a conclusion. Now, this involved, it was a conflict between two companies. They were small, medium-sized enterprises, both based in the EU, but in different countries, and in glass manufacturing. And company A, let's call it that way, filed a number of EUTMs, both word and figurative, at the EUIPO, and it was opposed by company B on the basis of that company's company name, right? So they didn't actually they weren't bringing forward a trademark, they were bringing forward a company name saying this company name prevents you from registering your trademark. Now, the problem was that the trademarks, both companies, the company name and the trademarks in question had verbal elements that overlapped in a descriptive element. So they were weak trademarks. Both companies had a number of national registrations, including in the whole of the EU, Switzerland, UK, Russia, and even China. And it turned out that China was actually quite an important market for both of them. And they had ongoing proceedings in the intellectual property offices of both Germany and Hungary. And both of them wanted worldwide solutions to all these problems. So what happened? Well, obviously, the first thing was that there were an awful lot of lawyers that were involved. And we had a question about in-house lawyers earlier in the day. And in this case, company A actually had 3 trademark attorneys, so outside lawyers, 2 in-house lawyers, plus the CEO. Well, the CEO, he came only for a bit, and plus an interpreter. So there were 7 people on one side sitting at the virtual table. And you can imagine that on the screen, there were quite a lot of boxes opening. And, you know, that was something that was somewhat challenging to manage, because also the trademark attorneys were in a different town to the company and the CEO. On the other side, you had company B that had just an external counsel, plus actually he had a trainee with him as well. And the CEO of the opposing company was sitting in the same room as him. And all this, of course, was online. Now, the day started off with a bit, because as we've said before, you have to go to the past in order to move the parties from the past to the future. Now, obviously, the parties here were a bit anchored with what I've called here the "you started it" syndrome. So the question was, who actually was responsible for having initiated the whole case, and each side blamed the other. Well, here I think what we had to do here was try and move them forward from this, because no one was ever really going to own up to being the aggressor. Each one was convinced that it was the other one's fault, and getting anchored on this question would have got us nowhere. So we needed to move forward, and we had several other challenges. Company A, with all these trademark attorneys, 3 external trademark attorneys, if you remember, they were quite, let's say, picky lawyers that were finding problems with everything and not really helping to move matters forward. And then their client, the CEO of the company, was disengaged. He came in the morning. He stayed for about 10 minutes, if I'm generous, and then told his people, "I've not got time for this. You do what you think you need to do and get on with it," basically. Now, that obviously made Company B, its CEO, who was with his lawyer in the room in another country, quite frustrated. He naturally asked, "Well, where's my counterpart? You know, I've made the effort to come here, and this guy's just gone off. You know, he's too busy. He doesn't care." So immediately, to move matters forward, this was actually a case. It was the case that Kasia was referring to that went on for 2 days. So at the end of the first day, things weren't going well at all, and the solution was to separate the people from the problem. This is actually something that mediators quite often refer to. And the way to do that was to put the 2 CEOs together. And so I got in touch with the CEO that had no time and said, "Look, things are not going well. If we're to move this, if there's any chance of getting a settlement in this, we need you to talk to your counterpart, and we need to move things forward, show that you care, you know, and etc." He understood that. We put the 2 men together, no lawyers. The only person that was there on standby was the interpreter, but in the end, he wasn't needed. And in fact, the CEO said, "Okay," the CEO of Company A said, "Well, what do you need, Company B? What is it that you really need? Just tell me." And then he said, "We need A, B, and C." And he said, "Okay, fine, let's get on with it." And that made the breakthrough, which then we were able to do a point-by-point negotiation. You'll remember from the morning that we said that we draw up an agenda for the day. Obviously, there were a number of items that needed to be negotiated, and we went through negotiating basically on use of the company name and the territories, things like use of the trademarks and company name on packaging, what would happen at trademark fairs, and looking at a long phase-out period of Company A's Company A's trademark, and that it could continue to use its company name, but in terms of having a trademark, it was going to look for a new trademark that wouldn't be problematic. We would have a phase-out period in order for them to do that. And then, so we got to the coexistence agreement, and there, what was a very good idea was that the Company B's lawyer had actually given a lot of thought to how he wanted the coexistent agreement to look like. Company A despite having 5 lawyers, had given almost zero thought to a settlement agreement. So company B actually had the upper hand, had an advantage because it already had ideas, and it could say, look, it said, well, why don't we set up a communication channel between the CEOs so that if there's a problem, first thing that happens is the CEOs talk and try and see if they can sort things out. Second thing, applicable law. Company A said, okay, how about we have the Vienna, we have, I think Czech law was the law that was suggested, which was the law of neither party. And we use the Vienna Arbitration Center for an arbitration. Company B, then the team of 5 lawyers woke up at this point and said, well, we absolutely don't agree with that. We don't want the Austrians involved. We don't want, well, they said we could have the Czech courts involved, but obviously you can't make somebody else's courts, give them jurisdiction in the matter that didn't concern them. So that was out. In the end, the compromise was that the ordinary conflict of law, the EU conflict of law, so Rome II provisions would apply, and that the same for the applicable jurisdiction, that would be also just governed by Brussels Judgment Convention criteria. Okay, so what happened was then we got a coexistence agreement in place. We actually drafted it at the end of these 2 days. And what was apparent was that company A, so the CEO that had no time, he was very quick to give consent to certain things. And that was a little concerning for company B, who sensed that maybe there could be a problem further down the line with this. So what they did, which was a very good idea, was to say, okay, we want a penalty clause in this settlement agreement. So if any of these conditions are not observed, then after having given notice and the CEOs having met, then there'll be a penalty that starts kicking in, and you will actually have to pay if you don't respect the obligations under this agreement. So I just throw that in as something that I think is a very good idea to have, because it will facilitate enforcement and make sure that what is supposed to happen happens. Obviously, what you have to watch out for is that the penalty clauses are not extortionate, and that they're reasonable and enforceable in the particular jurisdictions. And that's something that the lawyers would definitely need to address. Okay, so on to the second case. Now, the second case was quite different here. This was a 2-person Spanish company. It's a micro company, you could basically call it, that was doing environmental audit. Okay, quite an unusual, not the everyday trademark activity that we get, but there it was. Now, unluckily for them, they filed for a trademark at the EUIPO that was rather similar to the trademark of a very large multinational energy company. Now, it so happens that energy companies have to do environmental audits when they set up power generating centers and so forth. And so therefore, there was actually a conflict in this environmental audit. And the opposition was based on a number of earlier rights at international, EU, and national level. And this actually resulted in the trademark applicant filing a number of cancellation actions against all these earlier rights. So his tactic was to try and kill off the earlier rights to stop the opposition, a very common occurrence at our office. And also the EUTM applicant had registered or tried to register at national level in both the EU and the USA, trademark rights, the same trademark, but nationally and at international level. So what did that result in? That meant that the energy company was also bringing infringement proceedings against the EUTM applicant in Spain and a number of other EU countries. And there were threats that in the USA there would be proceedings as well. So basically what you had was a series of cross actions between these parties all over the all over the EU and international. And not surprisingly, significant fees were being incurred. Right? I mean, it was over 100,000 euros of fees were being incurred almost on an annual basis. It was ridiculous. Okay, so these parties had actually had negotiations in the past, and those negotiations had failed. And that's actually something that needs to be said, that what you have to do as a mediator, one of the questions when you're exploring is to find out whether there have been any negotiations, previous negotiations between the parties, and then try and find out, what went wrong and why were they not able to settle. Well, in this case, I think things had got very emotional on one side, and on the other, it was a very hard-nosed approach to business. So, the big energy company didn't want to be seen to be giving anything away for free, and therefore negotiations had failed. This was actually really a final opportunity to settle. If we couldn't settle this, then it was going to just explode into legal proceedings for eternity, basically. There was a significant legal or imbalance in legal representation. The multinational had its in-house lawyer. It had a French lawyer. It had a Spanish lawyer, and it had the director of finance there as well. It had a big team. On the other side, the little Spanish company, it was just really the owner of the company and his friend. He couldn't even at this stage afford a lawyer anymore because he had spent so much on all this litigation. So he had a friend come along, and the problem here was imbalance. How are we going to deal with that to try and keep things on an equal level? And in fact, this was a mediation that both Sven and I co-mediated, and we were very aware that of this imbalance, and we tried to make sure that things were kept as fair as they could be without obviously us losing impartiality by intervening. So we would obviously need to just remind the Spanish company of some realities. We'll come to that in a minute. Now, obviously, the multinational had some red lines in terms of its authority, which we didn't know and couldn't know. We knew, of course, that they weren't going to just give everything that the Spanish company asked for. The Spanish company actually asked for €1 million at first. And then Sven and I asked, well, how did you arrive at that figure? And they rather naively said, well, they had looked up on the internet about negotiation and seen that you always ask for double what you want. Because in the same way that there's an insult offer by offering something that's too small, there can also be an insult offer by asking for something that's totally unreasonable. And one of the things which I think goes to the point Sven was making about confidentiality is if you know the reasons why people ask for things and their reasons that can be given to the other side, that's always better, because then others can understand where you're coming from and understand your thought process, rather than just coming up with figures and saying, here it is, this is what I want, it's this or nothing. Obviously, you're not going to get very far with that. Now, of course, saying that you had read on the internet that €1 million was the right sum to ask for was not going to be the right thing to put forward, but at least we got the person thinking about whether his offer was reasonable, whether his request was reasonable, and how it might be perceived by the other side, and how he was going to be able to substantiate what he actually wanted. So reality testing, obviously we've mentioned about WAPDA, the worst alternative to a negotiated agreement. I have to say, since all of us at the that are doing this, we're trained as lawyers. Part of legal training is to always look at worst case scenarios. So we're rather good at the worst case. Maybe it's more challenging to be optimistic and look at the BATNA, but you can be sure that one of the parties will always come with the counterpart to that. And the reality is probably somewhere in between. But here, what was the important issue for the micro company was the emotional stress. And we actually asked the gentleman that was the owner of the company, well, how's this affected you emotionally over the years? And his friend said, well, my friend, he used to have black hair when this started. Now he's completely gray, and he's not sleeping well at night. And then this man said, yeah, it's so draining. I'm every weekend writing legal to lawyers and battling with this, and it's just consuming my whole life. So then he had actually started by having what I call kamikaze mode. And this is unfortunately something that's quite frequent, where you have a David and Goliath situation. Now, of course, in the Bible, David was very brave and willing to fight. What happens in reality is that David turns into a Japanese Second World War fighter pilot that is, orienting his pilot plane to the deck of some US naval ship, and is determined to take out as many people as he possibly can. And this is what happened in this situation. The small company said, I know I can't win, but I want to hurt these guys. They've ruined my business. They've just come after me in an aggressive way. I'm going to hurt them. And there you have to try and, reality test, saying, look, we understand what you're saying, but do you really think that you're going to be able to impact on a multinational by doing this? You've told us you've got all this emotional stress. Is this really what you want? So anyway, this led to the breakthrough where, of course, the person said, yeah, no, that's not really what I want. Now I really need to settle this and move on with my life. So the proposal here was to sell the trademark or the small company's trademarks to the big company by way so that they could have some defensive marks, and that everybody would drop hands, drop all the legal actions. And that's exactly what happened. Then there were some negotiations about the lump sum that would be asked for purchasing these marks. As I explained, that was a little tricky because the micro company was unrealistic about that. But again, with reality testing, we got down to an acceptable figure for everybody. And we drew up heads of agreement, because there's one thing we haven't really stressed is that often in one day, especially, it's not possible to draft, or it's not often possible to draft a full settlement agreement. We did do it in the last case that I told you, but in many times we just actually put down some points that are agreed on. So general principles of what's going to happen next, plus a timeline. So here that there'll be a purchase of the trademarks, that those trademarks will be used defensively, that all outstanding legal actions will be dropped. And by the way, at this point, one of the parties woke up and said, oh, we actually have some domain names. So then we had to sort of make sure that the domain names were also included in this agreement. And then the amount and then the timeline in which a negotiated agreement or settlement agreement, the final agreement, will be drawn up. That's all put on a piece of paper and signed by the parties. So it's an agreement to reach the final agreement with all the main points of what's going to happen. At this point, I'm going to ask Kirsten do you want me to stop here? I've one more case, but if we're running too over time, I'm happy to stop here.
Thank you, Gordon. Yes, indeed. The idea is to have some questions from the audience if this is wished, and then stop for a break at 2 o'clock and resume at 2:45. So depending on if there are questions, Gordon, then I would ask you to go on, or we stop here. So let me hear if we have some questions from the audience on the insights of this applied working methodology and the practicalities, and also the lessons learned from real mediation that Gordon has come through. We have a question from the hall, so let's focus on this. The question is, if neither of the parties is represented by lawyers, who is in charge of drafting the settlement agreement? And if only one of the parties has a lawyer, is the mediator responsible to supervise that the lawyer drafts the settlement agreement in an impartial way?
Well, it's an interesting question, and thank you for that question. Let's take the one where only one party has a lawyer, which was exactly this case that Sven and I were involved in. So what we did there is, it was a bit what I was saying about trying to keep a balance in these David versus Goliath situations. So again, Sven and I were doing the typing, and at this stage, everybody is round the table, and the one party had lawyers and the other party had just his friend. And obviously, we have to try and keep a balance. I mean, it's not for us to judge the fairness of the agreement. So if the parties are happy to sign an agreement, which maybe somebody else might consider as a bit one-sided, that's not our immediate concern if that is satisfactory to both of the parties. So I think here the first point is to make sure that the weaker party is happy with what he or she is signing, that they are content to sign what is being proposed. It's not our job to try and put that to question whether it's fair or not. We just have to make sure that they understand what they're signing and that they're happy to sign it. So of course, if they need any explanations, we would do that, but we would have to give those explanations probably in the presence of the other party to make it clear that we're not trying to influence in one way or another. We're just trying to keep a fair balance. I I don't know whether Sven maybe has something to
Yeah, Gordon. I would just, I mean, if we have lawyers on one side, on the other hand, we have no lawyers. It's the case Gordon just mentioned. I mean, agree what Gordon has said, but I think it's important is you also have to clearly go to the party who has no lawyer and say, look, this is the agreement. If you want to be 100% sure, you need to go to a lawyer and check it. You can trust the other party because we can't take the responsibility. It's not the job of the mediator, at least not for us in the EUIPO, to take any responsibility. And you have to be extremely careful because if there is a problem, they will come back to you and say, okay, you said that I can sign it, but there is a big issue here. So I think, at least in my mediation, make it very clear, look, if you want to sign it, it's your responsibility. If you're not 100% sure, I can't tell you if it's the right one. I can only tell you, you need to go to a lawyer and you need to get it double checked because it's a high responsibility, which is not, at least in our system, not the duty and not the responsibility of the mediators. And if you have no lawyers on both sides, I mean, that's actually a bit more tricky then. Again, I think the mediator should not engage here in suggesting, okay, I can make a settlement for you and you can just sign it. That's too dangerous. It's again, not our task. The big advantage we have here in the EUIPO is that we have a pro bono service, a pro bono legal service for SMEs. And then because that's usually when there are no lawyers, it's always SMEs. I mean, no big company comes without lawyers. So we're talking about 2 SMEs. And there we have the advantage and we can use our pro bono service and we can engage 1 or even 2 lawyers who would then support the 2 parties who have no legal representation to draft a settlement. Yeah, so that's a good system we have here in our office, the pro bono service for the SMEs. Thank you.
Yeah, maybe Kirsten, if I may, just to explain a bit what Sven said about the pro bono service. So this is a service particularly for SMEs in the wake of the COVID-19 pandemic, whereby the EUIPO has got a number or the names of a number of lawyers and trademark attorneys throughout the EU who are able and willing to act in trademark disputes or in or IP disputes of any sort, and they do this free of charge, and the EUIPO simply matches the party that wants to take advantage of this service to one of these providers. So we don't engage the lawyers as such. We simply provide a matching service. It's done by another department within the office, and it's obviously very good for those parties who cannot afford legal representation. Okay.
Thank you, Gordon. With this, I would like to thank you for your participation in this second session, and of course also the highlights from Sophie, Gordon, and of course also Sven. I hope you found these 2 morning sessions interesting and informative. For those of you who will not continue this afternoon, I'd like to greet you and look forward to seeing you on any other occasion.